Thank you, everyone, for joining us. My name is Jesse Berg, and I'm here with my colleague, Julia Ryland, and we are giving a talk on the HIPAA audit program that is part of our Foundations in Privacy Toolkit project, which Great Plant Moody has the privilege of working with the Minnesota Department of Health on. We've been working with the Department of Health for the past 18 months or so on a series of materials related to compliance with HIPAA and various other provisions of federal law and, of course, Minnesota law related to healthcare privacy. And today we are going to be focused on issues related to HIPAA audits. So, the Foundations in Privacy Toolkit that Great Plant Moody is working on, it lives at the website address that you see on this slide here. There are a series of documents related to the work we've been doing with the department available on this website. And if you go to the very bottom of the website, you will see a section of the document which gives several different links for presentations that Julia and I and our colleague Tim Johnson have done related to our work with the department. One of those educational seminars is an introduction to the toolkit. And rather than spend time today talking about background on our work with the grant and the health department, or details about the nuts and bolts of the toolkit and the different ways in which you can use the toolkit, we encourage you to take a look at the first presentation for an introduction on the toolkit work that we will be doing. We are going to be doing several more webinars related to various topics about the toolkit and our work with the health department. All of the webinars will be posted and live on the website at the link that you see here. If you are interested in learning about our work along with the department, please sign up for the mailing list or send either Julia or myself an email. Our email addresses are at the end of the presentation, and we'll be sure to include you on our distribution list for these materials. Some of the materials on the toolkit website are in the process of being updated, so there will be additional work rolling out in the next several months. We are also going to be doing several in-person events. We recently gave a presentation at the Minnesota eHealth Summit on June 15th, 2017. If you'd like copies of our materials from that presentation, let either Julia or myself know, and we'll be sure to get you a copy of those materials. And we will also be doing a session on the toolkit alongside representatives from the Minnesota Department of Health at our annual Health Law Conference that's going to be held on July 20th. We recently sent out invitations to the Health Law Conference. They were emailed out on about June 15th, I believe. If you receive that, we encourage you to sign up. It's a free event, and we do our best to put on a good full day of materials and educational seminars for our clients and for our friends about developments in the healthcare industry generally, and with privacy, of course, playing a specific area of focus in the health law seminar. If you didn't get a invitation and you're interested in attending, let either one of us know, and we'll be sure to send an invite out your way. So today we are going to spend our time talking about the HIPAA audit program. We're going to go through some of the nuts and bolts about how the audit program works, talk a little bit about enforcement, why it is that compliance is important and why folks should be paying attention to the audit program. And then we'll also spend a little bit of time talking about how to prepare for a compliance review. These materials and the information that we're talking about today, we decided to do this because there's really been a sea change in focus on compliance from the folks at the Office for Civil Rights out at the U.S. Department of Health and Human Services. Back in 2003, when HIPAA became effective, the focus on compliance from the OCR's perspective really was about education and awareness with an effort to try and educate health plans, healthcare providers about how to comply with the HIPAA requirements. There really wasn't as much attention devoted towards things like fines or publicizing any kind of sanctions or corrective action plans, less of a punitive approach when the law originally went into effect. That started to change approximately in about 2009 when we saw the HITECH Act passed as part of the stimulus legislation that President Obama signed into law in early 2009. And as a result of that, we've seen more and more of an emphasis from OCR and also from states' attorneys general on compliance and enforcement. Audits are important not only for the specific details of the HIPAA audit program itself, but also because organizations, as a result of HITECH, when they have a breach of unsecured protected health information, they're required to report information about that breach to the Office for Civil Rights. And when that happens, one of the things that typically occurs is that the OCR will reach out and investigate the breach. And what we've found and what our clients have found and others in the industry have found is that when that occurs, when OCR contacts an organization about a breach that they suffered, the materials that OCR looks for, the information that OCR wants to see, and the questions that OCR is asking really tend to be pretty similar to the kinds of things that are discussed in the audit program. So we wanted to spend a little bit of time talking today about the audit program, not only for the program itself, but also as an additional tool for folks to use in preparing for breaches. And if you're interested in breaches specifically, we already have a webinar up on our website that goes through HIPAA breach analysis and spends a fair amount of time walking through a number of different hypotheticals. So we'd encourage you to take a listen to those materials if that is of interest to you. And with that, I will turn it over to Julia to talk about the audit program.
Thanks, Jesse. So HITECH required OCR to perform periodic audits to ensure that covered entities and their business associates are in compliance with HIPAA. This was one of the first things that they started to do to really look at compliance efforts for HIPAA and take more of a proactive stance on it. One of the most important things that we're going to be talking about today is the audit protocol that OCR uses when they're conducting these audits. Back in 2011, OCR established what was called a pilot audit program to assess the controls and processes covered entities have and implemented to comply with them. Through this program, OCR developed what's known as the audit protocol, which is essentially just a set of instructions that OCR uses to really measure compliance efforts of covered entities and now their business associates. You'll see in just in a few seconds how detailed this audit protocol really is, with line-by-line explanations of the HIPAA requirements and how OCR will actually use this to assess compliance. And you can access the full protocol at this link that's on the slide. But here, let's just really dive into so that you can get a sense as to what the protocol looks like. This is an example of a privacy requirement. You'll see that the protocol is organized by rule and regulatory provision, and this is because it separately addresses the elements of the privacy, security, and breach notification rules. So this one here is for privacy, and it lists the regulatory citation. So if you're really into HIPAA, you'll be able to find exactly what rule they're looking into and going after. And here, the HIPAA obligation that they're auditing is whether the covered entity uses and discloses information consistent with the Notice of Privacy Practices. The takeaway that you'll notice from this protocol example is twofold. First, you'll see that the protocol requires OCRs to review every HIPAA requirement, no matter how small. So if anybody is thinking that, you know, this will only be an issue for impermissible uses or disclosures of PHI, or it will only be an issue for big HIPAA breaches, that's not the case. It really does dig into every HIPAA requirement, even the ones that you think are not particularly important. So second, the steps that OCR is supposed to take, you'll notice, are very extensive. Here, for this particular activity, OCR is supposed to inquire of the management whether the uses and disclosures of PHI are consistent with the Notice of Privacy Practices, actually obtain and review those those procedures, and then evaluate whether the uses and disclosures of PHI are in fact consistent with the Notice of Privacy Practices. You'll notice when you actually go to that link and look at the full protocol that this particular example is particularly small compared to some of the other ones. The protocol gets very, very detailed and extensive with very specific action items that OCR is supposed to take in regards to each of these HIPAA requirements. So with that backdrop in mind, let's dig into a little bit of exactly what the HIPAA audit program is. As we mentioned, in 2011, OCR initiated a pilot program wherein they developed this audit protocol that we've been talking about, and they tested it, and then they conducted a full range of audits using the revised protocol materials. OCR selected and audited 115 covered entities, and they intended at this time to really get a broad range of different covered entities. So this included providers and health plans and healthcare clearinghouses. The process is pretty interesting. If you look back at it, covered entities were informed of their selection and were asked to provide their privacy and security documentation, so essentially their materials and their procedure manuals, all within 10 days. So they did not have a whole lot of time to actually compile this. They had 10 days to put everything together to get it off to OCR so that they could perform their review. Initially, OCR would perform a desk audit, which just means that they would, back in their office, look at exactly what the covered entity was doing and do an initial investigation. But they did then go and perform site visits for each auditee and completed an actual audit report. The OCR did give auditees around 30 to 90 days notice when they were going to do a site visit, but at this point in time for this phase, everyone did actually receive a site visit. Following this, the auditors would share a draft of the report. The covered entity would have a chance to review it, make comments, potentially address any of the concerns that OCR had identified, and then at that point, OCR would prepare a final report for each and every one of them. So this, for those who are visual listeners out there, this is just a diagram of the process. It shows how quick this process was, with being notified of the audit on the first day, 10 days to actually prepare and provide that documentation, moving on to the on-site visit, to the draft report, so on and so forth. And I'll move it on to Jesse to talk about phase 2.
So phase 1 wrapped up, and OCR started phase 2 of the audit program back in April of 2016. Phase 2 was different in a couple different ways. One of the primary ways that it was different is that we were now having business associates who were subject to the audit program as well. Listeners will recall that business associates essentially are organizations that provide services to covered entities where the business associate service involves patient protected health information that's created or received by the business associate on behalf of the covered entity. And one of the big changes that came around when HITECH passed, and then when the HHS issued a series of regulations in 2013 known as the HIPAA Omnibus Rule, was that business associates themselves became directly regulated by HIPAA just the same way, for the most part, that covered entities were regulated by HIPAA. And while business associates had been forced, going back to 2003, to deal with HIPAA issues based on the contractual provisions that they agreed to in their business associate agreements with covered entities, they hadn't been subject to direct oversight by Office for Civil Rights until this time. So business associates have found themselves in the crosshairs a little bit because unlike health plans and unlike healthcare providers, business associates sometimes will have a less specific healthcare focus, and some of the detailed requirements of the HIPAA security rule in particular, and also various provisions of the HIPAA privacy rule that are relevant to business associates simply are something that business associates may not have been all that familiar with prior to this time. So starting in April 2016, OCR began looking under the Phase 2 program at covered entities, and then later in 2016 began looking at business associates. The Phase 2 program will supposedly consist of about anywhere from 200 to 250 audits in total. 200 of those audits will be desk audits, with a smaller number consisting of more comprehensive on-site audits. If you're interested in what OCR has in mind with the Phase 2 program, they did create a webinar back in July of 2016 that includes a helpful question and answer session on their audit program, talking about some of the steps that they're thinking organizations should be aware of, some of the pros and cons of taking various approaches. And if you're interested in that, please send either Julia or myself an email, and we'll get you a copy of the OCR materials. So what does the Phase 2 program look like? Well, there's a series of steps that are involved. It largely tracks the kinds of things that Julia talked about a few minutes ago in terms of the Phase 1 process, but it really begins when OCR sends out a pre-screening questionnaire to potential auditees. And if you'd like to see a sample of what that looks like, you can see that there's a link on this slide. Click on that, and you'll be able to take a look at what that notification questionnaire looked like. After that, OCR would send out a letter containing a list of documents that they wanted to see produced. Step 3 involved having to produce documents for review to the OCR prior to the OCR's visit and within 10 days of receiving a notification letter. The fourth step involved a site visit and interviews with management and personnel at the organization. Step 5, the auditor would draft a report. Supposed to take place and be finished up within 30 days of the visit happening. The entity then, the covered entity or business associate, would have 10 days to review the draft of the report, and we'd finally have a final report within 30 days after that. So probably the big takeaway for folks with this time frame is the importance of having materials related to your organization's HIPAA compliance in pretty good shape in advance of getting one of these inquiries from OCR. Because if you don't have your policies and procedures, your training materials, risk assessment, range of other documents, business associate contracts, notices of privacy practices, all of the other very granular materials that organizations need to have for purposes of compliance. If you don't have all of those things in fairly decent shape when you receive a request like this, it can be pretty challenging to have to scramble around and try to put things together quickly. And while there, is occasion to try and get extensions for document requests, and OCR has been cooperative with organizations as long as they believe the organization is responding proactively and is taking the document request seriously. It can take quite a while for organizations to get these materials organized put together in a comprehensive, clear way. So we really encourage folks to take a look at their HIPAA compliance materials and make sure that they're up to snuff, that they're specific to the organization at issue, and that they've been updated recently. So the scope of the audit, really is supposed to be, it's supposed to not be a punitive approach. The idea, again, is to try and look at what organizations are doing. OCR has indicated that they're going to be developing tools for the industry to use in terms of self-evaluation and breach prevention. Listeners probably are familiar with the OCR website, where you can find a great range of very helpful HIPAA compliance materials. The audit protocol, in particular, that Julia talked about a little earlier, is a really excellent document that organizations can use to try to see how they're doing with respect to compliance. There are a range of other materials as well, frequently asked questions, for instance, that OCR has available that really reflect, I think, a pretty dedicated and well-meaning effort by the OCR to try to help organizations have some of the tools necessary for compliance. The OCR, has said that they want their audit protocol to be something that's usable for a range of organizations, but not every organization is going to have the same amount of resources, the same type of technology, the same time and personnel capacity to devote towards compliance. So just be aware that those materials are out there, the compliance materials published by OCR, and they're intended to be something that organizations that don't have as many resources as others might be able to use for compliance. They're really there to try and help folks, so we encourage you to at least take a look at those materials. The OCR is not going to be looking at compliance with state-specific laws during these audit protocols. They're also not going to be billing the covered entity or business associates for the cost of the audit work as well. They hope organizations can learn from this program. As I mentioned, it's not supposed to be punitive, but they do make the point of saying that, if we've got organizations that have practices that suggest significant concerns with respect to compliance, the OCR does reserve the right to do a full compliance review. So, for instance, if we had a covered entity that didn't respond in a timely way to OCR's requests, and the materials produced by the covered entity suggested broader noncompliance, it might be fairly likely that the OCR would consider doing a broader compliance review at that organization. So just because you've submitted your materials doesn't necessarily mean that the story is over. So why do we care about this so much? Why do we care about enforcement and about compliance? Well, it's just something that's taken on a lot of interest in healthcare and in the U.S. economy generally. We've seen story after story about data breaches at various businesses, various companies. Probably a lot of listeners have received emails or letters that seem suspicious. Maybe you've had your credit stolen or some sort of suggestion of potential identity theft. Healthcare has always been the kind of industry that's subject to more regulation just because of the inherent sensitivity of the information at issue. And we're really seeing more and more effort on the part of regulators to make sure organizations are taking compliance with these issues seriously. If we do have noncompliance in the context of an audit, it is something that could lead to additional reviews by the OCR going forward. So organizations who are concerned about their own compliance status should really try and take heed of some of these recommendations from the government in terms of how your privacy and security materials look. So thinking now about what enforcement looks like and what are the kinds of things that we've seen in enforcement, I will turn it back to Julia.
So as Jesse mentioned, HIPAA enforcement really is on the rise. We wanted to give listeners some actual data so that they can see just how much these figures have increased over the years. So since 2003, OCR has reviewed over 154,000 HIPAA complaints and initiated over 810 compliance reviews. Of these, there were over 25,000 cases that actually resulted in required changes to the privacy practices and corrective actions. But what gets really interesting is when you look back at the data and see how things have trended over the years. So just looking at 2015, OCR investigated and resolved over 17,000 cases. In 2012, this figure was only slightly over 9,000, and then all the way back to 2003, we're looking at only around 1,500. So the original 154,000 complaints, that may or that may not be impressive to you, but what is important nonetheless is just really taking in the fact that these cases have become much more of a priority, and we expect that to continue to be the case moving forward. There are significant penalties in enforcement, so there are civil and criminal sanctions that are applicable if there have been HIPAA violations. Civil penalties we see more commonly, and they're assessed in actions, and the size can really vary just depending on the facts of the situation and the covered entity that's involved. But in the last year, these penalties have ranged anywhere from around 50,000 to 5.55 million. So you can really see a big difference between the penalties that are applied. What's important to remember also when you're thinking about penalties and assessing risk is the fact that harm really isn't required for there to actually be a civil penalty applied. So just for an example, in one case, PHI was left in boxes unattended in the driveway of a house, and there were no allegations that there was any unauthorized access to this PHI. There was no evidence that the records were taken or looked into, and there were no allegations that the PHI was lost. But nonetheless, a monetary penalty was assessed at the amount of $800,000. So there are a lot of things that can go into HIPAA enforcement and a lot of risk that is involved, and it's just important to be aware that these are real penalties that may be applied if your compliance isn't perhaps up to what OCR would hope that it would be. So to give listeners a sense of some of the types of actions that OCR is actually pursuing, we wanted to give you a few case examples that have come out recently. The first one that we're going to talk about today is CardioNet. So I'm just going to refer to this as CN. CN is a wireless health services provider that provides remote mobile monitoring of and rapid response to patients at risk for cardiac arrhythmia. So this case essentially had a laptop that was stolen from a parked vehicle outside of an employee's home. It contained PHI of over 1,000 individuals. OCR conducted an investigation, and ultimately they concluded that there were a number of HIPAA violations that resulted from this and that were actually ongoing prior to this theft. OCR concluded that CN had an insufficient risk analysis and risk management process in place at the time of the theft, and that the policies and procedures that CN had in place were not adequate. They were in draft form. They had not been customized or implemented for the organization, and in fact, a lot of them weren't final. Particularly, the one that they were concerned about was the policy that was supposed to safeguard ePHI for mobile devices. Ultimately, CN agreed to a $2.5 million settlement with OCR and entered into a corrective action plan. So this case here demonstrates how enforcement actions can evolve. OCR may start an investigation by looking into one issue of noncompliance. Here, that would be the HIPAA breach or the stolen laptop, but end up citing a number of other HIPAA violations, and this is just due to the nature of the investigation that OCR takes on. Here, OCR cited an insufficient risk analysis, failure to have policies and procedures, so on and so forth. And these were things that would not have necessarily been known had this HIPAA breach occurred to begin with. It's very typical in an enforcement action for OCR to look into a number of issues like this and go kind of beyond the scope of the actual HIPAA breach to begin with, and we see this happening in the audit world as well. The next case that we want to talk about is Center for Children's Digestive Health, or CCDH. In this one, in August of 2015, OCR initiated a compliance review. The issue here was that there was a disclosure of PHI to CCDH's business associate, Filefax, and the issue was whether that disclosure was permissible. OCR conducted a review and unfortunately concluded and discovered that there was no business associate agreement in place between the two parties. And because of this, OCR concluded that CCDH failed to obtain satisfactory assurances from Filefax that it would appropriately safeguard PHI. Ultimately, CCDH agreed to a $31,000 settlement and entered into a corrective action plan. They were required to develop, maintain, and revise their policy and procedures, particularly regarding business associates. And it also included actions like developing a template business associate agreement, developing a process so that they can assess their business relationships to make sure that they have the appropriate agreements and procedures and policies in place for those that are in fact business associates. And it also included workforce training. So for those of you who have attended our in-person trainings, you've heard us talk about the importance of executing a business associate agreement and maintaining these policies and procedures, in particular on business associate relationships. This is often an area that providers have trouble with and an area that OCR is really paying attention to. And this recent enforcement action just reinforces that. Fortunately here, the Foundation and Privacy Toolkit that we're here to talk about today does contain a lot of helpful documents in this area that should help you navigate some of these relationships. You're going to find a template policy and procedure document for dealing with your business associates. You'll also find a template business associate agreement and a flow chart to help you determine whether certain relationships do in fact fall within the realm of a business associate relationship. So all of these things actually kind of mirror up with some of the tools that OCR required this provider to put in place. And we're excited to talk with you a little bit more about some of these tools later on in the presentation. But look to the toolkit for those as you're thinking about your business associate relationships. So this leads us on nicely to our next topic today. We're talking about next how to really prepare for a compliance review. So even if you're not selected for an OCR HIPAA audit, it's very important that you are prepared for a compliance review at any point in time, because as Jesse mentioned, a compliance review can result from not only just a HIPAA audit, but it can come about as part of an enforcement action, or it can simply be through reporting a HIPAA breach or any sort of other impermissible use or disclosure. In light of this, we're going to spend the remainder of our presentation talking about some of the steps that you can take to better position your organization for a compliance review. So one of the first things that you should do is review that audit protocol that we've discussed earlier from the pilot program website. You can access it here. We've included the link, I think, twice now because it really is important that you look this over and get a sense as to the type of requirements that OCR is expecting your organization to comply with and the types of actions that OCR will take when they're actually assessing your compliance. So look this over, become very familiar with it. We recommend kind of using this as a tool to assess your own compliance. You can go through it and note those items that you think you have satisfied, but more importantly, identify those that you think are lacking at this point in time. The critical point here is then to follow through on making those points, those lacking issues, and bringing them into compliance with HIPAA, because we've found out from OCR and we've had regulators tell us that although it is good to do an assessment, what's even more important is to make sure that you take the necessary action following that to bring your organization in line with HIPAA requirements. Another first step to do, if you haven't already done this yet, is to conduct a risk analysis. This is really the first step to identifying and implementing safeguards that comply with and carry out the standards that are part of the security rule. So during this analysis, you need to look into how PHI flows in and out of your organization, whether you have effective administrative, technical, and physical safeguards in place, and then develop risk mitigation plans for those safeguards that are not appropriately addressed by your organization at that time. This risk analysis is, in fact, required under HIPAA, so if you don't have one of these completed yet, or if your analysis is outdated, it is really crucial that you take this step as soon as possible. HHS has developed a security risk assessment tool that will take you through this process. You can find them online, and if you have trouble finding them, feel free to let Jesse or I know, and we can connect you with some of these materials. You'll find them to be very thorough, and by that I mean they are very lengthy, but they really are great tools as you think about your risk analysis and as you proceed down this process, because they go through, you know, each and every requirement and have you thinking about what your organization is doing to comply. Another thing that you should do, of course, is to review and update your HIPAA policies and procedures. As I mentioned, regulators have some concerns over organizations that don't actually use and implement these policy and procedure documents. There's often this idea that you can purchase or download a template document set and put it on your shelf and you'll be good to go and you'll be covered for HIPAA. And I'm sorry to say that that's not just going to do it. So you really need to make sure that these policy and procedure documents are customized to your organization, that they address the issues that you're facing, and that they're actually being used and that they're living and breathing documents and they're not just collecting dust on your shelf. We do have some helpful documents as part of the privacy toolkit that we've put together. These can be used to maybe replace if you have an outdated document, to supplement if you like your document but you have new issues that need to be addressed, or they can be used for training purposes. I'll point you to this one here, which is a template HIPAA breach policy. You'll notice that there are helpful, drafter's notes in these policies, but there's also things that you're going to need to revise. For example, in this page you're going to notice that there's the word organization that's italicized and in brackets. You're going to need to take and download these documents from our website and customize them as appropriate. This means adding your logo, putting your organization's name in there, and most importantly, reviewing to make sure that this policy does in fact reflect how your organization operates. This may require, and likely should require, revisions to the document, but it really will give you a good starting place when you're thinking about your breach protocol. You should do this for all of your policy and procedure documents, not just those that are in the toolkit. We, of course, weren't able to cover everything, and so your HIPAA policies and procedures should be far more robust than the toolkit policies are, but at least the ones that we have will give you a good start. You should also review and update some of your other privacy documents. For example, you should make sure that your HIPAA authorization form is valid. We do have a HIPAA authorization form checklist as part of the toolkit, so you can use this to verify that the one that you're using does in fact comply with HIPAA. You can also download, we have a link here, to download the standard consent form that was prepared by the Minnesota Department of Health. This is a great resource. It can be used by your organization and it complies with both HIPAA and Minnesota law. Another thing, as we've talked about, is to review your business associate agreements. This is directly relating to that enforcement case that we were talking about, and we do see this to be an area that organizations have trouble with. So use the toolkit documents. We have template business associate agreements that you can customize. You'll see that there are drafter's notes in there. You can create your own template that's directly customized for your organization and make sure that your relationships actually have this agreement as required. Finally, look at your notice of privacy practices and your other patient forms. Again, we've included one more link on here for a model notice of privacy practices that was prepared by the Minnesota Department of Health. Feel free to use this document. It'll go over all the requirements. You'll be good to go with this one, or use it again as a reference if that's helpful. And I'll turn it to Jessie. Oh. This is one more, this is just the template business associate agreement. Sorry everybody, but I wanted to include this here because it shows you just how important it is for you to review these documents in the toolkit and then customize them. At the very beginning you'll see that there's a GPM drafter's note. This is something that is really just to be read and reviewed by the drafter. It's not intended to be part of the agreement. So this whole section in bold and in brackets at the very top should be removed. This is going to be consistent throughout the document. So this serves as a helpful reminder that the documents that are part of the toolkit really are supposed to be customized, and you'll have to make sure that you review them before you implement them.
So there's a lot there and a lot of really terrific recommendations from Julia and in the materials that we've put together in the toolkit and on the OCR webpage as well. But one of the most important things that any organization can do, regardless of how many people it has working there, regardless of its level of resources, has to do with training your personnel, training your employees. Your employees are likely your greatest strength, and that is terrific. The thing to know for HIPAA purposes, though, is that employees can also be a big weakness if an organization isn't taking compliance and training seriously. Having the best, most comprehensive, well-written, thorough policies and procedures is not going to do very much for an organization if the folks charged with implementing those materials don't really know how they work and don't really understand the scope of what's required of them. So we really want to encourage listeners to think about whether training has happened recently, whether training has been thorough, whether training has tackled the kinds of challenges that your organization has faced in the past. Certainly if you've had a breach, if you've had compliance problems in the past, taking a step back and thinking about whether there are things you can do differently at your organization to try to minimize the chances of something similar happening in the future, or trying to use maybe a problem that you experienced as a teachable moment for your team, can be a really effective way not only of improving your employees' performance and minimizing the chances of HIPAA problems happening in the future, but it also shows a very demonstrated effort towards compliance that you can give to the regulators, that you can show to the Office for Civil Rights or the State Attorney General in the future if you ever are under audit or if you ever do have a breach. We really can't say it enough because it's important to be able to demonstrate that you took the time and you devoted the attention towards getting your team all on the same page when it comes to compliance. OCR very, very often will ask you not only for copies of the training materials that you've used, but they'll also want to see logs of people at your organization and whether they attended training. If it was a quiz, question and answer type of training session that you used, for instance, they may even want to see the results. Now, you may be able to redact certain pieces of identifying information about your personnel in producing those materials to OCR, but if you're able to at least show them what you used to train and you can prove that your team went through the training process, you'll be able to demonstrate an effort to comply that will probably serve you pretty well in the event that you are under an audit or investigation. And it's not just your privacy and security leadership that needs to be tasked with training. The OCR really wants to see whether management at the organization is invested in the topic. They certainly want to know whether the folks that have the day-to-day burden of complying with HIPAA and dealing with PHI, whether that portion of your team has gone through the right type of training. And that really demonstrates another point about training that we want to make, and that's that the best way to do this is if you can make sure that your training is specific to your team. So if you've got people at the front desk, for instance, who might be checking patients in, and then you've got someone in the billing office who is going to be seeing PHI every day, maybe submitting different kinds of claims, maybe working with business associates. A reasonable question to think about is whether those two individuals should be subject to the same type of training or whether they should be going through something different. You'll want to do this when you bring new people on board at your organization. You'll want to think about training whenever you've made material changes to your policies and procedures. Certainly if the regulations change in the future, you'll want to think about whether you should do any kind of updated training. And it's also a good idea to try and do refresher training courses going forward as well. OCR also wants to find out whether organizations are thinking about assessing the kinds of risks that are particularly important at an organization. So this slide talks specifically about encryption, but it could really be anything. Julia mentioned the HIPAA risk assessment that's required under the security rule. OCR will almost certainly be interested in when you did your last risk assessment and what the results of that risk assessment were. If you uncovered problems in your risk assessment, they're going to want to know, what did you do to try to fix those problems going forward? Did you take steps to try to address the issue, or did it just kind of sit there without any sort of remediation happening? And it's a question that can be challenging to answer if you didn't take steps to address an identified problem. So if encryption is the particular issue that you're thinking about, you'll want to be asking yourselves questions like, well, you know, what kind of mobile devices do we have? Do we engage in the emailing of PHI? Do we text PHI? Do we store PHI, you know, off-site? And if so, what are the kinds of things that we've done to try and protect that information from being accessed? Now, if you spent time looking at the security rule before, you'll notice that encryption technically isn't something that's required for covered entities or for business associates. It might make sense for certain organizations to do that, particularly if you have the resources or if you have a large amount of PHI that you're working with. But not every organization is going to be able to afford encryption, or encryption might not be practical for every organization that's out there. So if you're the type of organization that's decided that encryption doesn't make sense for one reason or another, the thing to know is that you're going to need to be able to explain, if OCR comes knocking, what did you do in lieu of encryption? What was your analysis that you walked through internally in deciding whether or not encryption made sense, and why is it that you decided it didn't make sense? And if you did decide that it didn't make sense for your organization, what was the alternative that you selected? An organization that's at least able to demonstrate that it walked through that analysis and it made a reasoned decision why encryption didn't make sense, they're probably going to be in better shape than an organization that simply didn't pay attention to the issue at all. The last thing we'll say about encryption specifically is one of the great things about encryption, if you can go this direction, is that if you encrypt your information in a way that meets certain standards adopted by NIST, National Institute of Security Transaction Safeguards, you can put yourself in a position where if you have a breach of what would otherwise be unsecured PHI, you don't need to go through the breach notification process. Now, what's important to know about this, though, is that the devil is in the details, and if you want information about the NIST standards, you should take a look at the OCR website where they have detailed information about what exactly is required. It's certainly not enough if you just rely on something that is quote-unquote encrypted but isn't going to meet the NIST standards. Organizations also want to be able to keep track of all of the materials that they have in place, not only on encryption but on all of the other things that we've talked about. So the various business associate agreements and subcontractor business associate agreements that Julia mentioned, the risk assessment that we've been talking about, any of the internal auditing that's required under the HIPAA security rule, having that information available in a way that's easily accessible and can be produced to OCR when they come around looking for it is very, very helpful. Other things that are pretty basic under the HIPAA security rule but might be surprising in that some organizations just haven't paid that much attention to those things are also worth noting. So what I mean by that, if you start going through the HIPAA security rule, you'll see that it talks about some very basic things that are pretty common sense business practices, not just in healthcare but in any business. Things like requiring your employees to use passwords on their computers that are a certain strength, that have a certain number of characters, that are reset within a certain number of days, having screens that lock when somebody is away from their desk for 10, 15, 20 minutes, and that require login when the person comes back to the desk. Having personnel at your organization wear badges or identification, particularly if they're in the part of the office where patient information is available. All of those kinds of things are really simple steps that organizations can do to address compliance. And if you can do those things, what we like to call low-hanging fruit, you're at least able to prove up to OCR in the event of an audit or in the event of a breach or in the event of a complaint that's investigated, that even if your performance with respect to HIPAA security or privacy isn't perfect, you've actually done quite a bit to try and tackle the compliance obligations that are out there. And that does a great thing for most organizations in terms of minimizing penalties and putting you in a better position going forward. So what do the auditors think about? What do they care about? Well, one of the big reasons that they focus on in terms of non-compliance was organizations that aren't aware of some of the requirements. Now, HIPAA is technical, it's very detailed, it's very prescriptive, but it's also been around now for a number of years. 2003 is when we saw the privacy rule go into effect. 2005 is when the security rule went into effect. The OCR and other regulatory agencies, they're not going to have indefinite patience about organizations who try to make the point that they're just not familiar with the requirements at issue. Employees, as we already kind of talked about, really they're your greatest strength and they're potentially your biggest weakness. So anything you can do to try to get your team up to speed on compliance obligations will be really, really helpful. It's not uncommon for OCR to want to talk to people at the organization and see whether folks on your team really understand the burdens that are expected of them. So just be aware that it might not be your top expert on privacy who's answering the phone when OCR comes and talks to you. Being organized for compliance, Julia already talked about the importance of having materials that are relevant to your organization, that make sense for your organization, that are tailored to your organization. That's very important because it shows an effort and a genuine intent to try to comply with the law. It's also really challenging if you are subject to an audit or if there is a breach at your organization and you get a letter from OCR. You may find yourself in something of a panic, and it can be really hard to get everything put together at the last minute and organized in a comprehensive way. It's much better if you can at least point to documents that you have for your team that are up to date, that are accessible, and that make sense and are tailored for you, because again, it shows an effort on your part to try and comply with the rules. There are also various pieces of unfortunate events that are happening in the healthcare world that are kind of ironically targeting folks that are doing their best to comply with these rules. And back in fall 2016, back in November 2016, OCR put out an alert that had to do with a phishing scheme that was styled as a very specific official OCR audit communication that is pretty well disguised. And as listeners probably can relate to, some of these emails that you get that are scams, they're pretty good. They're pretty sophisticated, and it's really easy to fall prey to them if you're not focused on compliance. So this is exactly the kind of training that we're talking about when we talk about training. Even if it's something simple like an email to your team that summarizes what you see on a slide like this, you're able to then show OCR that you took their advice seriously, you spent the time to try to educate your employees about what's happening, and you are, doing your best to comply. And even if there's a problem, even if somebody unfortunately were to click on the link and information was accessed as a result of that, you at least can show OCR that, we did our best to try to comply. We took some steps to comply. And again, that intent is really important in terms of getting penalties reduced going forward. Another example would be ransomware. OCR recently put out guidance on what organizations should do with respect to ransomware. So if that's not something that you've thought about at your organization and you're not sure if you've got the time or the resources to spend on putting together a whole big review about ransomware, a starting point would at least be to take a look at the OCR guidance on ransomware and to push that out to your team so folks there have a chance to see what the government is recommending in those situations. There are unfortunately other things coming down the pipe in terms of compliance going forward. HITECH's been on the books since 2009, but when you see people from OCR out talking about HIPAA these days, they make it very clear to folks that, that more is happening. We've got at least two big parts of the HITECH rule that are relevant to covered entities and business associates that are going to be coming out at some point. We don't know exactly when, but some point relatively soon, we would think, and those have to do with the proposed rule on accounting of disclosure requirements that was issued, I believe, back in 2010. It really expanded the accounting of disclosure obligations in a way that a lot of people in the industry found to be extremely burdensome. There was a lot of pushback on that accounting of disclosure requirement, and HHS has indicated that they've been working on the issue and they'll be putting out a new series of regulations on that specific requirement some point relatively soon. You should remember that that's a statutory requirement from HITECH. So the expansion in the accounting of disclosure requirements under the HITECH statute probably isn't something that's just going to go away. We may not see quite as burdensome of a rule as we saw under the proposed rule from 2010, but you will probably be seeing some change in your obligations with respect to accounting of disclosures. And then the other one that's important and is really relevant to this seminar today is another statutory change from HITECH having to do with a provision that would give individuals a portion of the financial recovery that OCR gets in the event that OCR receives a complaint about a HIPAA violation, investigate things, determines that there's a problem, imposes a fine, and recovers that fine. The idea is that a percentage of that fine recovered would go to the individual who suffered the harm. And as folks who are familiar with the Civil False Claims Act know, when there are laws out there that create this kind of financial incentive to blow the whistle, whether the conduct that resulted in the whistle was being blown was truly wrong, or whether it was a mistake, or whether it didn't really happen, sometimes can be a little bit beside the point, because the financial incentive can drive the volume of complaints that are filed just through the level of public interest as a result of that financial recovery being out there. So we don't know exactly what this is going to look like, but OCR has been talking as recently as this summer about how they're putting out, or they're going to be putting out guidance on that requirement as well. And finally, they've also said that they're going to be putting out more frequently asked questions related to some of the dicey issues that folks have probably been struggling with in recent years, and that would include things like social media in healthcare settings, using text messages to communicate with patients, and the always challenging minimum necessary rule, which requires organizations to use and disclose only the minimum amount of PHI necessary for the use and disclosure at issue. So please pay attention to all of those developments. We think that they're likely to be pretty important for covered entities and for business associates. Thanks very much for listening to us today. Julia and I really appreciate your attention. If you have questions on any of the things that we've talked about, or if you would like additional information or links to any of the things we've discussed, please feel free to reach out to either one of us at the contact information you see here, and we will be sure to follow up with you. Thank you.